Hi students, welcome to this live session on RTP discussion for CA Foundation Business Law. We have Aslesha with us. Aslesha, you can carry forward the session.
Thank you.
We'll wait till the times students join in. Few students have already joined in.
Sure.
You can also keep the YouTube live thing open. I'll send you the link. And if at all you have some questions, you can take it up from there.
Sure.
You can also keep the YouTube live. Yeah, students have started joining in, so you can continue.
Okay. Good evening, everyone. Hope you're all doing good. So today we are going to discuss the RTP of CA Foundation, paper 2, business laws. So we are going to discuss part A, that is your business laws RTP for May 2022 examination. So let's start. So I'm not able to share my screen.
I'll just make it a poster. Yeah. Now I think you'll be able to share. Are you able to share now?
Yes.
Sure.
So is my screen visible? Are you able to see my screen?
Yeah, it's visible.
It's visible.
Yes, we have some 20 of our students who have joined in, so you can continue. Yeah.
So let's start with the RTP. Let's start with the first question. So the first question is based on unlawful consideration, and let's have a look at it. So A enters into contract with B that he sells his house for rupees 10 lakhs to B. Further, they both signed an agreement that if B uses the house for gambling purposes, then B shall pay A rupees 50,000 for it. So what is happening here? There are two agreements which are coming into existence. One is that A and B enter into an agreement to sell house for rupees 10 lakhs. And there's another agreement, and that is if B uses the house for gambling purposes, then B shall pay A rupees 50,000 for it. Now what happens? Let us have a look at it. B agreed to this. However, after a year of sale, B started gambling business in that house. The question is asking us, can A claim rupees 50,000 from B? Discuss with reference to the provisions of Indian Contract Act 1872. So this is something which is an example given in your study material, and I believe most of you would have recollected this example as in when we were reading the question. So I will not go into details of how are you going to write the answer, but I'll just give you a brief that there are two agreements which are being entered here in this case. One is a valid agreement and the other is illegal, or the purpose of which is illegal. So the first agreement, that is agreement to sell house, is valid, but the second one, that is the that is using the house for gambling purposes, it is not a valid agreement, it is illegal. So both these agreements are severable in nature. So when they are severable, the valid part is enforceable, but the invalid part is not enforceable. So the question here is asking us, can A claim rupees 50,000? So the answer to this is definitely no. A cannot claim rupees 50,000 from B. So here you can also have a look at the answer to this question. So according to section 24, when some part is legal and other part is illegal, the question arises about validity, and there we look at whether the contract is severable or not. And on the basis of it, we decide which part is enforceable and which part is not enforceable. Let's now move on to the second question. So the second question is, Seema was running a boutique in New Delhi. She has to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. So what has happened here, there's a person, Seema, she's running a boutique in New Delhi and she has to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. Now what Seema does is she delivered the sewing machine and some cloth to a railway company. So Seema, she's delivered the sewing machine and cloth to the railway company so that the company carries this sewing machine and cloth to the exhibition place. Now Seema expected to earn an exceptional profit. So here's the first keyword, that is, she expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of railway authorities. Now, as soon as we read this, does something come to your mind? We have read this kind of example in our study material as well in the form of a case law. And the name of the case law is Hadley versus Baxendale, wherein we have studied this when we were discussing the types of damages which can be claimed in case of breach of contract. So here as well, what are the different types of damages? General damages and ordinary damages. Now with this term exceptional profit, what do we understand? That Seema was expecting to earn some exceptional profit from this exhibition, but she did not make this fact known to the railway authorities. Now let's see what happened ahead. The goods were delivered at the place after the conclusion of the exhibition. So what has happened? The Seema sent the goods for the purpose of exhibition, but there was a delay and the goods reached the place only after the exhibition was over. Now, on account of such breach by railway authorities, can Seema recover the loss of profits under the Indian Contract Act 1872? So here the question is asking us, can Seema recover the loss of profit under the Indian Contract Act 1872? So if we apply what we have studied in the case law of Hadley versus Baxendale, Seema is eligible to claim damages, but only general damages and not loss of profits, because this will amount to special damage. And since Seema did not make the railway authorities know the purpose for which she is sending, and also she did not make them aware that she would miss upon exceptional profits if there was a delay, so Seema is eligible to claim only and only general damages or ordinary damages and not special damages. So this was with respect to question number 2, and here's the answer. You can have a look at the answer. Yeah. So yes, you can quote the name of the case law, Hadley versus Baxendale, as has been quoted here. And finally, end your answer with the conclusion. Moving on to the next question. Chandan was suffering from some disease and was in great pain. So there's a person, Mr. Chandan, who was suffering from some disease and he was in great pain. He went to Dr. Jhunjhunwala, whose consultation fees was rupees 300. So Chandan, he goes to Dr. Jhunjhunwala, whose consultation fees was rupees 300. The doctor agreed to treat him, but on the condition that Chandan had to sign a promissory note of rupees 5,000. So what is happening here? The actual consultation fees is only 300, but the doctor pursues him to sign a promissory note of rupees 5,000. So what is happening here? There is one party who is in a position to dominate the will of the other party. So we will apply the provision with regard to undue influence in order to answer this question. Let's look at what happened ahead. So Chandan signed the promissory note and gave it to the doctor. On recovering from the deceased, Chandan refused to honor the promissory note. So what has happened? At the time of signing the promissory note, Chandan agrees because he wanted to get his treatment done. So he signed the promissory note, but later on, he refused to honor the promissory note. Now, the question asks us, state with reasons, can doctor recover the amount of promissory note under the provisions of the Indian Contract Act 1872? Now, you tell me, can the doctor recover the amount on the promissory note? So I'm waiting for your answers for a minute. Do you think the doctor will be able to recover the amount on the promissory note, 5,000 rupees from Chandan? Yes, no. So the doctor can definitely not recover the amount. Why? Because the contract was made under undue influence. And when the contract is made under undue influence, wherein one party has taken undue advantage of the other party, in that situation, the contract is voidable in nature. And Chandan here, who is the aggrieved party, does have a right to avoid the contract. So this is how you will answer the question. Now, it is very important that when you're reading the question for the first time, you highlight certain keywords and understand what are the keywords, like we are doing it now, right now. So when you're first reading the question, look at what is required and highlight the keywords and then start answering it. Let's move on to the next question. So the next question is, Mr. Asim, a learned advocate, his car was stolen from his house. He gave an advertisement in the newspaper that he will give a reward of rupees 10,000 who will give the information about his car. So here there's a person, Mr. Asim, who has published in the newspaper that his car is stolen, and whoever brings the car to him, he'll give a reward of rupees 10,000 to that person. Now, Mr. Vikram, he reads the advertisement, and on making some efforts, he got the stolen car. So what is happening here? The car was actually stolen, and Asim gives an advertisement. Another person, Vikram, he reads the advertisement and he makes some efforts and is also able to get the stolen car. Now, after he gets the car, he informs Mr. Asim about it. Mr. Asim found his car but denied giving the reward of rupees 10,000 to Mr. Vikram with the words, an advertisement in newspaper is just an invitation to make offer and not an offer. Hence, he is not liable to make the reward. So what does Mr. Asim say? He says that I have made an advertisement in the newspaper and it is an invitation to offer, not an offer. Hence, I am not liable to give any reward to you. Now, the question asks us, state with reasons whether under the Indian Contract Act 1872, Mr. Vikram can claim the reward of rupees 10,000. So here the question is asking us, can Vikram claim the reward of rupees 10,000? So what comes in your mind as soon as you read this question? I'm sure the case of Lalman Shukla versus Gauri Dutt would have come to your mind. But there, the situation was different. There, the person was not aware of the offer which was made. But here, Mr. Vikram is aware of the offer and he is acting on the offer, which means Mr. Vikram has accepted a general offer, and Mr. Vikram here is entitled to receive or is entitled to claim the reward of rupees 10,000 from Mr. Asim. Mr. Asim cannot deny stating that it was only an invitation to offer. So here in the situation, a general offer is coming into existence, and as we all know, when a general offer is something which can be accepted by public at large. So in the situation, Mr. Vikram can claim the reward. He is eligible to claim the reward of rupees 10,000. Let's move on to the next question. So next question is, Mr. Singhania entered into a contract with Mr. Sonu to sing in his hotel for 6 weeks on every Saturday and Sunday. So there's an agreement between Mr. Singhania and Sonu that Sonu will sing at his hotel on every Saturday and Sunday for 6 weeks. Mr. Singhania promised to pay rupees 20,000 for every performance. For every performance, Mr. Singhania has promised to pay 20,000 rupees to Sonu. Mr. Sonu performed for 2 weeks, but third week, his health condition was very bad. So he did not come to sing. So Sonu, he performed for 2 weeks, but third week, he did not turn up. Mr. Singhania terminated the contract. Now, since Sonu did not turn up, Mr. Singhania, he terminates the contract. That is, he cancels the contract. State in the light of provisions of the Indian Contract Act 1872. So we have 3 questions here. Let's look at each of them one by one. Can Mr. Singhania terminate the contract with Sonu? So do you think he has the right to terminate the contract with Sonu? Can Mr. Singhania terminate the contract? Yes, he definitely can. If you remember, we have studied this in the Unit 4 performance of contract, that when one person willfully does not turn up and does not perform, then the promisor, he gets a right to repudiate the contract, and not only repudiate but also claim damages. So yes, here Mr. Singhania can terminate the contract. The second question asks us, what would be your answer in case Mr. Sonu turns up in 4th week and Mr. Singhania allows him to perform without saying anything? So here the question is asking us, and what if Sonu turns up in the 4th week and Mr. Singhania allows him to perform without saying anything? Then in that situation, here by his conduct, Mr. Singhania is inferring that he is interested in continuance of the contract, and now later on he cannot repudiate the contract, but yes, he can still claim damages from Sonu. Let's look at what the third point asks. What would be your answer in case Sonu sends Mr. Mika on his place in 3rd week and Mr. Singhania allows him to perform? So in the third situation, what is happening? A third party is performing the contract on behalf of the party to the contract, and the performance is being accepted by the promisor. So in this situation, again, Mr. Singhania cannot repudiate the contract because he has accepted the performance of a third party. So which section are we using here? We are using section 41 of the Indian Contract Act to answer the third part of this question. Is this clear? We can have a look at the answer here. So as we've discussed, in the first situation, Mr. Singhania can repudiate the contract. Second situation, he loses his right to terminate, but yes, he can still claim damages. And in the third situation, Mr. Singhania, he has accepted the performance of a third party. So later on, he cannot repudiate the contract, stating that Sonu did not turn up. So whenever you're writing answer, first here clearly write the provision you're using to write the answer. And then finally, when writing the conclusion, give your conclusion. Let's move on to the next question. So the next question is a direct question. I don't think there's a need of a lot of discussion for this particular question. So the question says, an anticipatory breach of contract is a breach of contract occurring before the time fixed for performance has arrived. Discuss stating also the effect of anticipatory breach of contract. So here you will have to first give the meaning of anticipatory breach of contract and then discuss what is the effect. So two things which you'll have to write here, that is the person can either repudiate the contract immediately or he can wait till the date of performance and then take the course of action. So this is a direct question, does not need a lot of explanation. We've discussed this in detail in our course. So let's move on to the next question. AB Cloth House, a firm dealing with the wholesale and retail buying and selling of various kinds of clothes, customized as per the requirement of the customers. They dealt with silk, organdy, cotton, khadi, chiffon, and many other different varieties of cloth. So there's a cloth house which deals in different varieties of cloths. Mrs. Rima, a customer, came to the shop and asked for specific type of cloth suitable for making a sari for her daughter's wedding. She specifically mentioned that she required cotton silk. So Rima, she specifically mentioned that she requires cotton silk cloth, which is best suited for the purpose for which she wants the cloth. The shop owner agreed and arranged the cloth pieces cut into as per the buyer's requirement. So Rima, she has ordered cotton silk cloth. The shop owner agrees to it and also arranges the pieces of cloth cut into pieces. When Rima went to the tailor for getting the sari stitched, she found out the seller has supplied her cotton organdy material. So what has happened? What material did Seema order? Seema ordered for cotton silk cloth, but here when she goes to the tailor, she finds out that she's not been given cotton silk cloth, rather it is cotton organdy material which is being supplied to her. So there's a mismatch. The cloth was not suitable for the said purpose. It was heavily scratched and not suitable for making the sari that Rima desired for. So it was not suitable for the purpose which Rima had bought. The tailor asked Rima to return the cotton organdy cloth. Sorry. Okay. Sorry. As it would not meet the requirements, the shop owner refused to return the cloth on the plea that it was cut to specific requirements. So when Rima, she goes to the shop owner again, the shop owner, he refuses to return the cloth, stating that the cloth has been cut into your specific measurement, so I cannot do it, and hence could not be resold. With reference to the doctrine of caveat emptor, explain the duty of the buyer as well as the seller. Also explain whether Mrs. Rima would be able to get the money back or the right kind of cloth as per the requirement. So here the question is asking us three things. One is, first you will have to explain whether Rima would be able to get the money back, and also we have to explain two more things along with it, and that is what are the duties of buyer and seller according to the doctrine of caveat emptor. So here But obviously, Rima is entitled to receive the money back, or either the right kind of cloth back. Why is that so? It is because Rima did specify what she wanted, and the seller, he is obligated to sell the material which is reasonably fit for the purpose for which it is being sold. So here in this question, first you will have to explain the duties of buyer as well as the seller, and finally conclude your answer with Rima. Yes, she would be able to get the money back, or she is entitled to get the money back, or the right kind of cloth, whatsoever may be the requirement. And why is that so? Because the seller is obligated to provide a material which is fit for the purpose for which the buyer is purchasing it. Let's now move on to the next question. So A went to B's shop and selected some jewelry. He falsely represented himself to be a man of credit and thereby persuaded B to take the payment of check. So there's a person, Mr. A, who has gone to B's shop and he selects some jewelry and he falsely represents that I'm a credit worthy person, and thereby he persuades B to take the payment by check. He further requests him to hand over the particular type of ring immediately. A also tells B that please hand over the ring to me immediately. On the due date, when the seller B presented the check payment, the check was found to be dishonored. So what has happened on the due date when B presented the check for payment, check bounce ho gaya, check was dishonored. Before B could avoid the contract on the ground of fraud by A, he had sold the ring to C. So what has happened here? There are three people, A, B, and C. Now B has sold a ring to A, but A obtained the ring under the means of fraud, which means the contract between A and B is a voidable contract. Now what happens? B comes to know about this only when he deposits the check and the check is dishonored. Now, meanwhile, what has A done? A has already sold the ring to another third party, C, and C has taken the ring in good faith. The person C, he has taken the ring in good faith and also without notice of any fact that the goods with A were under a voidable contract. So here, what has happened? C has purchased the good or purchased the ring from A on good faith and does not know about the voidable contract between A and B at all. Now here the question is asking us, discuss if the sale made by non-owner is valid or not as per the provision of Sale of Goods Act 1930. So simple. We know that the sale can be done only by the owner of the goods. Only who has the title is entitled to sell the goods. But there are exceptions to this, and this situation which we are discussing about here falls under the exceptional criteria. That is, when sale is made by a person who is in possession of goods under a voidable contract. So using this exception, we will answer this question, and we've already answered the question, half the question already when we were reading the question. So here, yes, in this situation, the sale made by A is valid. Why? Because C purchased it in good faith and without notice of any fact. And also A sold the goods before B could resign the contract. So this is how you are going to answer this question. Let's move on to the next question. The next question is nothing but a copy paste from your study material. So we'll not go deep into it. So you basically have to classify transactions into types of goods which they represent. So the first one is wholesaler of cotton having 100 bales in godown agrees to sell 50 bales, and these bales were selected and set aside. So the first is ascertained goods. Second is A agrees to sell B 1 packet of sugar out of the lot of 100 packets, so which means unascertained goods. And the third one is with regard to future goods, wherein there's an agreement to sell apples which will be produced in the garden. So that is with regard to future goods. So you only had to identify which type of goods are being asked, and this is a question which frequently appears in your RTPs and is also a part of your study material. So let's quickly move on to the next question. Okay. Certain goods were sold by sample by A to B. So there is sale by sample which is happening here in this situation, and the goods are being sold by sample by Mr. A to Mr. B, who in turn sold the goods by sample to C and C by sample to D. So what is happening here? There's a circle which is being made. First, A sold the goods to B by sample. B sold the goods to C, again sale by sample. And C sold the goods to D, again sale by sample. Now, the goods were not according to the sample. So there is sale by sample, and we know there's an implied condition in case of sale by sample, that is the bulk should correspond the sample in quality. And also the buyer should have a reasonable opportunity to check the goods. Now here, the goods which are being sold, they are not according to sample. Therefore, D who found the deviation. So until the goods reach D, no one else in between, that is B and C, found out about the deviation from the sample. D found the deviation of the goods from sample and he rejected the goods and gave notice to C. C sued B and B sued A. Now you have to advise B and C under the Sale of Goods Act 1930. So here we are talking about an implied condition, and that implied condition is implied condition where the sale is happening by sample. And when sale happens by sample, the bulk shall correspond the sample in quality. Now here D, yes, he has a right to reject the goods and also recover damages. But B and C, they can only recover damages or claim damages, but they cannot reject the goods. Why? Because they already accepted the goods when the goods were sold to them. So when they already accepted the goods and further made a sale of the goods, they cannot reject the goods, but yes, they can still claim damages. So using the implied condition of sale by sample, we have to answer this question. So this was again a very simple question. I'm sure most of you would have been able to answer it even before I am discussing here with all of you. So let's move on to the next question. Sohan, Rohan, and Jay were partners in a firm. The firm is a dealer in office furniture. They have regular dealings with Messrs. AB and Company for the supply of furniture for their business. On 30th June 2018, one of the partners, Mr. Jay, died in a road accident. The firm has ordered Messrs. AB and Company to supply furniture for their business on 25th of May 2018. So the firm made the order on 25th of May, and on 30th of June, Mr. Jay, he dies. But the order was placed when Mr. Jay was alive. Now Sohan and Rohan continue the business in the firm's name after Jay's death. The business of the firm is still continuing, which means they would have agreed that death of a partner will not have any impact on the existence of the partnership. the firm did not give any notice about Jay's death to the public or the persons dealing with the firm. Messrs. AB and Company delivered the furniture to the firm on 25th of July. So there are 3 dates. Date 1, 25th of May, when the order was placed. Date 2, 30th of June, which is the date when Mr. Jay dies. And date 3, 25th of July, and that is the date when the furniture was actually delivered. Now let's look at the required part of the question. The fact about Jay's death was known to them means Messrs. AB and Company at the time of delivery. Afterwards, the firm became insolvent and failed to pay the price of the furniture. So what happens later? The firm becomes insolvent and fails to pay the price of the furniture. Now, Messrs. AB and Company filed a case against the firm for recovery of the price of furniture. With reference to the provisions of the Indian Partnership Act 1932, explain whether Jay's private estate is also liable for the price of furniture purchased by the firm. So here, this question is similar to the example which has been given to you in your study material. Yes, the names are different, but the question is completely identical to the example which is there in your study material. So here again, we know that the estate of the deceased partner is not liable for any acts of the firm which are done after his death. In this situation, though the order was placed before Mr. Jay died, but the furniture was actually delivered, the liability was actually incurred after his death. So in this situation, Mr. Jay's estate will definitely not be liable for the price of furniture. So the estate is absolved. Estate of a deceased partner is absolved from all the liabilities as soon as he dies. So from the date of his death, his estate is no longer liable. So here as well, Mr. Jay's private estate is not liable to pay the price of furniture which was purchased by the firm. So again, a very simple question, which is nothing but an example of your study material which has been replicated. Now, what happens is most of the time in examination as well, what you get is a question which is actually an example given in your study material, but yes, with names changed, with dates changed, and with amounts changed. And we get confused there itself. So that should not happen. And that will not happen when you have understood the concepts correctly. So let's move on to the next question now. So the next question is, Moni and Tony were partners in a firm, Messrs. Moto and Company. They admitted Sony as a partner in the firm, and he's actively engaged in day-to-day activities of the firm. So which means that Sony is a working partner. Now, what makes us come to this conclusion? This term actively engaged in the day-to-day activities of the firm. There is a tradition in the firm that all active partners will get monthly remuneration of 20,000. So there's a tradition in the firm that all the active partners will get a monthly remuneration of rupees 20,000, but no express agreement was there. So this was just in the course of dealing of the firm, wherein this was fixed that all the working partner will get a monthly remuneration of 20,000, but there was no agreement to it. After admission of Sony in the firm, Moni and Tony were continuing to get salary. So after Sony enters in the firm, Moni and Tony, they were already working partners and they are continuing to receive the salary. But no salary was given to Sony. So Sony, though he was also a working partner, he was not being given any salary from the firm. Sony claimed his remuneration but denied by existing partners. So now Sony, he also says that I'm a working partner and I want remuneration for this, but he was denied by the existing partners, that is Moni and Tony, by saying that there was no express agreement. So Moni and Tony give him a reason that there's no express agreement and we are not there is no duty to pay remuneration to a partner. Whether under the Indian Partnership Act 1932, Sony can claim remuneration from the firm. So I'll not answer this question, but I want all of you to give me answer to this question. What do you think? Can Sony claim remuneration from the firm? Do you think Sony is eligible or entitled to claim remuneration from the firm? So I'm waiting for your answers. Do you think Sony can claim remuneration from the firm? I'm waiting for your answers. Could you be a little quick? The facts of the case are very clear. He's okay. Ashwin says he's entitled to receive remuneration as per section 13A. Okay. Anyone else would like to add up to this? Okay. Okay, Shakuntala also says Sony can claim remuneration. So yes, both your answers are correct. Sony can claim remuneration. Now here, let me walk you through this particular question, because this type of question has not been asked earlier, and this is something new. And here, there's no express agreement. And also, if you remember that there's no obligation to pay remuneration to the partners. And why is that so? Because they already get a share in profit, and there's no obligation to pay remuneration. They do not have any right to receive remuneration. But yes, with an express agreement or by course of dealings, the partners may receive remuneration from the firm. And here in this situation, what is happening? There's a custom in the firm that the working partners or the active partners, they will receive a monthly remuneration of rupees 20,000. But yes, there's no express agreement to it. But now when Sony is admitted, he's also a working partner, and according to the course of dealing of the firm, that is a monthly remuneration of 20,000 has to be paid. So applying that provision here, yes, Sony is entitled to claim remuneration. Yes, he cannot be denied by Moni and Tony stating that there's no express agreement and hence we will not pay anything to you. So no, they cannot say anything like this. And yes, Sony is entitled to claim remuneration. So here you can have a look at the answer. Okay, just give me a minute. There's some issue with the. I'll reshare my screen. Just give me a minute. Okay, give me a minute and I'll be back with the screen. There's some technical issue. Apologies for that. Meanwhile, you can ask me any doubts if you have.
So that is nothing wrong with this fact. How long you cheating and beating out the bush. So as he said, we will throw it back to you. Now please let us know. Do you want to know that?
Yes, sir.
No.
Yeah.
No, let us
I
know.
believe you are able to view my screen
True,
now.
to know what kind of things we need to know.
Why are we even able to that books? Then how do we handle it?
So
Then what is
you can have a look at the answer here.
Wait, statement. Fine, but it is absolutely right. Then what is the
No, but we are not rubbing. We are not taking names.
personalized knowledge is all.
We said, but sir, again, said we cannot take the names. We'll say you want the names, we'll give you. We'll have it.
Am I able to?
No, sir, I think that is the.
So yes, Sony is eligible to receive the remuneration. Let's move on to the next question quickly. Apologies for the technical issue.
Ashlesha, any help needed? Sorry.
No, it's fine. Some problem happened with the laptop. It's fine now.
Okay.
Yeah, so moving on to the next question. Mrs. XYZ and Company is a partnership firm. The firm is an unregistered firm. The firm has purchased some iron rod from another partnership firm, Mrs. LMN Company, which is also an unregistered firm. So there are two firms here. They have entered into some purchase contract, and both of the firms are unregistered firms. Mrs. XYZ and Company could not pay the price within the time which was decided. So the purchase was made, but this firm, Mrs. XYZ, could not pay the price within the time which was fixed. Mrs. LMN and Company has filed a suit against Mrs. XYZ and Company for recovery of the price. So here there's this other firm, LMN and Company, which has filed a suit against XYZ for recovery of the price. State under the provisions of the Indian Contract Act, the first part asks us whether Mrs. LMN and Company can file the suit against Messrs. XYZ and Company. Now, if you remember, if a firm is unregistered, it does not have a right to sue another party or another firm. So in this situation, both the firms are unregistered, and hence as a result of which both LMN also cannot file a suit on XYZ. Only if LMN is a registered firm, it has a right to file a suit against XYZ and Company. The second part of the question asks us what would be your answer in case XYZ and company is a registered firm while LMN and company is an unregistered firm? So do you think the answer will change in the second situation wherein one firm, that is XYZ and company, is registered but LMN and company is unregistered? Do you think there will be a change in the answer? Do you think there will be a change in the answer for the second situation? In the second situation, XYZ and company is registered, whereas LMN and company is unregistered. So do you think now LMN and company can file a case on XYZ and company? One is registered, the other is unregistered. Okay, so here again, the firm which is suing, that is LMN and company, is unregistered, and hence it does not have a right to file a suit on a firm which is registered. So again, in the second situation, the answer would be same. No, LMN and company, being an unregistered firm, cannot sue XYZ and company. Moving on to the last part of the question, which says, what would be our answer in case XYZ and company is an unregistered firm while LMN and company is a registered firm? So here the roles have reversed. The case is different, where XYZ is unregistered and LMN is registered. So even if a firm is unregistered, it can be sued upon by a registered firm or by any other person. So here, yes, in the last situation, our answer will be yes, LMN can file a suit against XYZ and company. In the last situation, wherein XYZ is unregistered but LMN is registered, and it gets a right to file a case on XYZ and company. So this is the answer to this particular question. You can have a look at the answer here. So according to section 69 of the Indian Partnership Act, an unregistered firm cannot file a suit against third party, and that is the provision we have used here. But yes, there is no prohibition on a third party to file a suit against an unregistered firm. So in first two situations, since LMN is unregistered, it cannot file a suit. But yes, in the last situation where LMN is registered, it can definitely file a suit against XYZ and company. Let's now move on to the next question. So next question is from LLP Act. Again, a straightforward question. Now, doesn't require a lot of explanation. So the question is, LLP is an alternative corporate business form that gives the benefit of limited liability of a company and flexibility of partnership. So here, this is a direct question for which you will have to give a direct answer in paragraphs or either in points. First, you will have to explain the characteristic of limited liability of a company, which is there in LLP as well, and then how LLP also enjoys the flexibility of a partnership. So direct question which requires direct answer, so not a lot of explanation needed here. You can have a look at the answer here. Let's now move on to the next question. So Jagannath Oils Limited is a public company having 220 members. So Jagannath Oils Limited, it is a public company. It has how many members? 220 members, of which 25 members were employee in the company during the period 1st April 2006 to 28th June 2016. So here the company has total 220 members, but out of these 220 members, 25 members were employee in the company, and they were employee of the company for the period 1st April 2006 to 28th of June 2016. They were allotted shares in the company first time on 1st July 2017, which means these people were allotted the shares when they were employees of the company. Now, remember this information. This information is very useful for solving the question. So these people, they became the members of the company when they were employees. And now, after the first allotment, these shares were sold to them, which was sold by them on 1st August 2016. So these employees, they sold the shares again on 1st of August 2016. After some time, on 1st of December 2016, each of those 25 members acquired shares in Jagannath Oils Limited, which they are holding till date. So what has happened? They were initially allotted shares, which they sold on 1st of August 2016. Now, after this sale, they again reacquired the shares on 1st of December 2016. And now the company wants to convert itself into a private company. So public company may, we know there's no restriction on the maximum number of members. There can be n number of members. But in case of a private company, there's a restriction, and the restriction is of 200. Now let's look at the first part of the question. Whether Jagannath Oils Limited is required to reduce the number of members. So the first part asks us, is the company required to reduce the number of members when now that it has to convert into a private company? So there are 220 members in this company. The total number of members is 220. Now, the trick here in the question is only with respect to whether employees will be counted or will they be excluded. Now, you all know that when we are ascertaining the number of members in a private company, employees who are members of the company will not be counted, and ex-employees who were allotted the shares during their employment, but though they are no more employees, those employees will be excluded. But here what has happened, these people were in employment till 28th of June 2016 and not after that. After 28th of June, they were no more in employment, and the shares were allotted. That is, the present allotment was made on 1st of December. That is, after they ceased to be employees of the company, which means they were not employees of the company when the present, according to their present holding. So in this situation, in the first situation, Jagannath Oils Limited, yes, it is required to reduce the number of members because the number of members is 220, which exceeds the maximum limit which a private company can have. So in the first situation, yes, a reduction in the number of members is required. But let's now look at the second part of the question. The second part says, would your answer be different if the above 25 members were an employee of the company for a period from 1st April 2006 to 28th of June 2017? So you see here, the year has now changed from 2016 to 2017, which means now when the allotment was made, or now when they acquired shares on 1st of December 2016, they were the employees of the company. So in the second situation, our answer will definitely be different, because in this case, we will not count those 25 members, or rather 25 employees, as members of the company. They'll be excluded when we are ascertaining the total number of members, and which makes the total number of members in Jagannath Oil Limited as 195. Why? Because 220 is the total number of members, and we are not counting those 25 people because they were allotted shares when they were in employment of the company. So yes, in the second situation, our answer will definitely be different. Why is that so? Because the people who were allotted shares on 1st of December 2016 were still the employees of the company, which was not the case in the first situation. So here you can have a look at the answer for a better view or for a better understanding. So first you will have to give the definite meaning of a private company and also state that who are the people who will not be included when we are ascertaining the maximum number of members, that is 200. So that is people who are in employment and ex-employees who were allotted shares when they were in employment. And finally, write your answer to both the both question A and question B. So here's the answer to both the questions. You can have a look at them and then we'll move on to the next question. So in the first situation, yes, the company is required to reduce the number of members before converting because the present number of members is 220. But in the second situation, there's no requirement to reduce the number of members because when we ascertain the total number of members, it comes to 195, which is well within the limit of the maximum number of members, that is 200. So let's now move on to the next question. A, B, and C decided to set up a new club with the name ABC Club, having objects to promote welfare of Christian society. They planned to do charitable work or social activity for promoting the artwork of economically weaker section of Christian society. So here what has happened? There are three people who come together, they want to form a club and they are doing it with some purpose, with the objective of promotion of artwork. Now the company has obtained the status of a Section 8 company, which means this is a company which is formed with charitable objectives and it started operating from 1st of April 2017. However, on 30th of September 2019, it was observed that ABC Club was violating the objects of its objective clause, due to which it was granted the status of Section 8 company. Now, all of you know very well that if a company wants to get itself registered as a Section 8 company, it requires a license. Permission from or approval from central government is required. A license is required. Now, what has happened? 2 years after the company starts its operation, it is found out that the company is violating the object, that it is not working according to its object clause. Now discuss the powers which can be exercised by central government against ABC Club in such a case. So this is a very simple question. We know the CG, they can revoke the license, yes, but when they are revoking the license, they'll also have to give an opportunity of being heard to the company. And there are three things which the central government can do. First is they may order winding up of the company. They may order the company to wind up. Second thing which central government can do is change the name of the company, that is add the words limited or private limited and convert the status of the company. The third thing which CG can do is amalgamate the company. Amalgamate the company with another company having similar objectives. So this is a very straightforward question. You don't have to give an analysis of the case and do any such thing here. You can directly write the answer of what are the powers which can be exercised by CG. So CG, that is central government, they have the power to revoke the license, and any of the three things can be ordered by the central government to the company depending on public interest or depending on what the central government deems fit. So here you can have a look at the answer to this question. So directly Section 8, where you will give an introduction about formation of the company, and then what will happen if a company which is formed with charitable purpose or some object of promoting some activities and it is not following it or is doing something, is violating the license, then in that situation, the CG has the 3 powers, and you list down the powers which the central government has. Let's move on to the next question. So this is the last question of your revision test paper. Let's start. An employee, Mr. Karan, signed a contract with his employer company, ABC Limited, that he will not solicit the customers after leaving the employment of the company. So Mr. Karan, he has signed a contract with the company where he was earlier working, that he will not solicit the customers after he is leaving the employment. But after Mr. Karan left ABC Limited, he started up his own company. So after leaving the company, after leaving the employment of ABC Limited, Karan starts his own company, PQR Limited, and he starts soliciting the customer of ABC Limited for his own business. So he had initially promised, he also entered into a contract that he'll not solicit the customer, but now he is doing that thing. ABC Limited filed a case against Mr. Karan for breach of the employment contract and for soliciting their customers for his own business. So now ABC Limited comes to know about this, and they file a case against Karan that Karan has made a breach of contract and he is soliciting their customers for his own business, that is for the business of PQR Limited. Mr. Karan contended that there is corporate veil between him and his company, and he should not be personally held liable for this. So yahan pe Karan, he is acting smart, and he says that there's a corporate veil between me and my company, and I should not be held liable for anything which happens in the company. So I am not personally liable. There's a corporate veil. So in the context, the company ABC Limited seek your advice as to the meaning of corporate veil and when the veil can be lifted to make the owners liable for the acts done by the company. So now this question is again based on a case law, and that is Guilford Motor Company versus On. I'm sure most of you would have been able to recall or recollect the name of this case law. So here, first you will have to explain what is the corporate veil, meaning of corporate veil, that there's a separation between the management and the company, the owners and the company. Then you'll have to explain what are the 5 situations where the corporate veil can be lifted. So you do not have to explain each situation in detail, but rather just name the 5 situations where the corporate veil can be lifted, wherein the company is formed to avoid legal obligations or evade taxes, for fraud, or for the purpose of defrauding the creditors. Could be any. Write all the 5 points where the corporate veil can be lifted, and then in this context, you will have to state, can Karan be made personally liable? So in this situation, but obvious, by the corporate veil will be lifted because Karan, he has made a breach of contract and he has made the company wherein there was improper conduct, there was fraud which was happening, and also he was avoiding a legal obligation. Which legal obligation? The obligation which was imposed on him by the contract which he entered into with ABC Limited, that he will not solicit the customers of that company. So in this situation, corporate veil will be lifted and Karan will be held personally liable for his act. So he'll be punished. Let's have a look at the final answer and then we can conclude the session. Meanwhile, you can ask me any doubts if you have. So, like we've already discussed, first you'll have to give the meaning of corporate veil, then what are the situations where the corporate veil can be lifted, and based on the facts or based on the provisions and also the case law of Guilford Motor Company versus Mall, the company, the corporate veil will be lifted, and yes, Karan shall be made personally liable for the acts of the company. So this was the last question of the revision test paper. Meanwhile, you can ask me any doubts if you have. So, yeah, before I conclude the session, I would just say that keep studying and stay connected. You can reach us for any doubt on forums. And also now is the time when you start practicing, and practice will happen when you solve as many mock tests as you can. So we have our own mock test series. You can solve, you can give those mock tests as well. And also the mock tests which are organized by the institute. Do give as many practice tests as you can. They will surely help you in evaluating yourself and also understand that where do you stand and what is your level of understanding the concept. So I'm open for doubt for 2 more minutes, and then we can conclude the session. So any questions, anyone, any queries on anything? We are open for 2 minutes. Any questions, anyone? Okay, we'll keep this in mind, that Ashwin. Meanwhile, if you have any doubts, I'm here and you can ask your questions. Okay, so let's conclude the session then. All the very best for your examination. Stay connected. Stay connected to us, and do reach out to us for any help. You can use our application. You want an ABC analysis, so we already have an analysis of past examination papers on our website and also on the app. So you can go have a look at it, and it has a very broader analysis of what are the topics which have been covered in the past examination as well, which will be a real help to you. So you can have a look at that. Okay, so no doubts. Okay, then fine. Let's conclude the session. It was a great time with all of you. Thank you so much. Take care.